Madam Chairwoman and members of the committee, good to see you again.
Good to see you again.
Please excuse my non-formal appearance. I was doing domestic violence training today. I do want to address members who have spoken. The deficiencies that you all have mentioned have been my passion and my work at the Academy for the last 8 years. I am committed and I bleed purple, if you know what I mean. So I want y'all to know that I am working extremely hard, and there's people out here that I've worked with on this issue, and they know that I am committed with everything that I'm worth to correcting, especially any deficiencies that I can address with the Academy. A couple things that I would like to mention is I encourage, again, these members, always demand superior service from your law enforcement officers. It does bother me personally when I hear that the trainings, the 40-plus hours, almost 100 hours of training that I give at the Academy, people are dropping the ball. That bothers me personally. I take it as a personal commitment and a personal issue when officers do not toe the line of basic standards of service, superior service that we promote at the Academy. So demand superior service from the law enforcement agencies, and if need be, talk to the chief or sheriff. One thing I would say is that we've talked a lot about fear of victims. Our suspects do not fear the system. There's a statement, and I'll have to alter a little bit, but there's a statement by Lieutenant Colonel Jeff Cooper, who's retired and deceased now, but he said, the only way to curb crime is with the victim themselves. For therefore, the offender does not fear the offender does not fear the courts, does not fear law enforcement, and does not fear punishment. But we should empower them to fear the victim. Let me alter that a little bit. It goes back to the offender having fear. Now, I'm not saying we need to be a bunch of jackbooted thugs, but they simply just don't care what we do. So, to some extent, law enforcement is limited by the statutes that you give us. What I'm able to do and what I'm not able to do is guided by the words of the law. Probable cause, reasonable suspicion, that sort of thing. So as we look at this collectively and as we look at laws potentially needing to be changed, I am in full support of the Attorney General's office going with the degrees rather than the repeated incident, but degrees and increased penalties. Another big issue that I brought to the committee's attention was the judicial dismissals. In that regard, as I wrap up, there was some discussion on body-worn video cameras. I've been working on that issue for about 5 years. That is great, but I still think a lot of these issues come back to judicial dismissals. We are not looking to take away a judge's discretion. That's something they have to have. But I will tell you this. When a law enforcement officer brings evidence-based prosecution, not testimony-based, that has to be reliant on the victim, but evidence-based prosecutions in front of the court, and officers are getting kicked in the teeth, bringing these cases to the prosecutor and the judge basically begging for the chance to show this physical evidence, and they're told, we're dismissing this case because the victim has failed to appear. What incentive is there for law enforcement to maintain a high standard of investigative response? Because they know, if I take this case to the prosecutor and the prosecutor knows that the judge is not going to entertain this case simply because the victim's not here, the prosecutor will plead it out to something less than CDV. And so I kind of see it as a top-down type thing. When officers know they're going to get a fair shake, they will put forth more effort. That once they leave the academy, my influence over them stops. And that's what I see as a real problem. Officers simply just want a fair opportunity to be heard. And when they're not getting the fair opportunity, it not only endangers them, it endangers the victim. And I know a lot is tied to money, but this issue of strangulation, the repeated uses or violations of bond, the repeated uses of the battery intervention program when they should only be used one time. These things don't require money at all. It just simply it requires a change in thought. That's it. I'm in full support of this gentleman and all these other people needing some more funds to promote those, what I believe is building that nucleus of the family and influencing these young people. But from the law enforcement side and our ability to do things, it's a change in thought process, not so much money. We've got the resources. We've got the cameras. We've got the people. We just need a change in the thought process for the statutes that we're able to enforce and how we're going to do it. And one more thing I'd like to add before I step down. One of the statutes in South Carolina, CDV, says that any investigation, any complaint of domestic violence must be investigated by law enforcement, regardless of how long ago it happened. It could happen 20 years ago. And I mentioned something to the effect of that we have things in the law that say must or may. Must are things that I have to do because you tell me. As a member of the legislature, as the laws of South Carolina, I have to do. But one thing that doesn't back that up, this particular part right here, is that if I'm mandated to investigate a complaint of domestic violence, regardless of how old it is or whether I was present or not, there's nothing that says I have to file a report. There's nothing that says I have to document it on a state-certified incident report. And that can be problematic, because I'm going to tell you right now, someone comes to a law enforcement agency and they investigate. I tell this as a best standard of practice at the academy. We tell them, if you go to a scene and there are the dynamics of a domestic violence, whether you arrest anyone or not, it is in your best interest and the best interest of the victim to file an incident report. Because if it's not documented, it didn't happen, and we have to create a paper trail and show a pattern of abuse so that when these individuals do go seek orders of protection, whether it's through the family court, magistrate, or hopefully we can address this at a bond hearing, it's there. So that's something that we'd like to see, is mandated incident report being filed and maintained by the agency. And the reason I say that with an official case number is because, to give you an example, when I worked for the Irmo Police Department, we had something called a Form 800. It was something that was basically, if you want to give me some information, I can write it down, but at a certain point in time, it was put in the garbage can. On an incident report, it is maintained to infinity. It doesn't go away. It stays in that computer system. It's not getting trashed. And any law enforcement agency that would contact me, the Attorney General's office, I would have that available to give them and show that, 8 months ago, 9 months ago, there was this threat, there was this actual act of violence or something like that. So that's something that we might consider as well. And, of course, if you have any questions, that'd be...
Thank you. Representative Weeks has a question.
Yes, sir.
Actually, I want to address two things. The first one, the last thing you talked about was mandated incident reports.
Yes, sir.
I mean, that seems to be a matter of policy that could probably be resolved by some executive director providing some directives for his department. Why has that not been dealt with by our chief law enforcement officials or even departmental law enforcement officials in our various jurisdictions?
Representative Weeks, honestly, I don't know. Like I said, since I've been at the academy, and I'm going to talk to my director, because one thing I would like to do is I would like to extend to the committee. I don't want to speak on behalf of my director without approval, but I would like to invite you to attend my criminal domestic violence training class at the academy. And to answer your question, I address that issue as a standard of best practice. We should always do an incident report, but again, you're correct. There's no state mandate for it, and it does need to come through a policy and procedure directive from that agency as a best practice. I can suggest, but...
Yeah, well, I suggest that you do suggest it.
And I do. I do. I always do.
Because I really don't, I mean, we should not have to go through the statutory process.
And I agree.
For something like that. And that should be a common sense operational policy or procedure the way I see it. But
I totally
I
agree.
think we should, with what we'll get out of this, maybe we'll have a whole list of recommendations. What do you think?
I think we'll have a
I
laundry
think
list,
so.
a long
I think we'll have
laundry
a
list.
pretty good list.
I have one follow-up
Absolutely,
question.
go right
The
ahead.
other question that I have, what do you teach your law enforcement officers in the academy regarding the issue of the enforcement of family court orders of protection?
Well, as a matter of fact, I covered that today. That was one of my 2-hour blocks today. Basically, what we do is we tell them their courts of jurisdiction, that the family court is the first court of jurisdiction when the family court is not in order, that the magistrates are available for emergency orders of protection.
Exactly.
And that obviously municipal judges at this time do not have the authority to issue an order of protection. That the duration of those orders last 6 months up to a year. An emergency hearing can take place within 24 hours. A standard hearing is within 5 to 15 days. And that those are for the purposes of criminal domestic violence situations or criminal sexual assault that pertains to a minor. The guardian can go on behalf of the minor. Another thing that we tell them, we give them all the information about the enforcement of foreign orders of protection, those outside the state of South Carolina.
Okay, can I interrupt you?
Sure.
Without going to the foreign orders of protection, let's talk about the domestic
Yes, sir.
orders of protection that are issued by our family courts. Obviously, and I was very disturbed by the lady who testified before she really kind of caught me, gripped me with her testimony, particularly as it related to the orders of protection and the enforcement part of it all.
Yes, sir.
And I think part of her statement was that they really don't have much power at all, that there's no force and effect of domestic orders of protection. And this is going to be an area that I'm going to be very concerned that we take care of
Yes, sir.
as we do the work of this committee. And I was just wondering, do you get feedback from persons who say that, well, we've got a system in place and it's a good system, but it's not working? Or do we just need to change the system? And I that's what I'm really trying to get a distinction on here.
Well, we do tell the cadets that there is a mandatory arrest for the violation of an order of protection.
That's my understanding, yes.
There's mandatory arrest. Now, to that extent, I know that each individual law enforcement agency will look at the facts and the circumstances as presented to see if they have established probable cause. But we do, in fact, tell them that it is a mandatory arrest for the violation. I do get some feedback, and I do get fairly frequent phone calls, both from citizens of South Carolina and from law enforcement officers who face some tough situations like, well, we do have some indications that someone violated, but I don't have enough evidence. I haven't been able to establish enough probable cause to get the warrant. I don't have the video. They do have statements sometimes that they are able to take and put into the affidavit for the warrant. So although they know that there's a mandatory arrest, each case is specific as to the amount of evidence that's there to establish the probable cause. And when that evidence is limited, they're having some problems getting a judge to give a lawful arrest order for it.
Thank you, sir. Thank you, Madam Chair.
I hope that answered the question, Representative.
Absolutely. Representative Talon?
Thank you. I'm equally as concerned about the order of protection and the enforcement of an order of protection. Tell me what happens when a person is finally arrested on order of protection. How long does it take him or her to get a hearing before a family court judge? Do they get out on bond? Then they go to the family court judge? How does that work? Because I've been told that when a person is picked up on an order of protection, it's just like anything else. They're out of jail, boom, and it's going to take 3-6 months to get a hearing in front of a family court judge.
Yes, there's a couple things that take place. Number one, since it is a criminal offense under our code, and I make the arrest, I'll use myself as an example, I make the arrest, they will be booked in and charged under that statute, violation of an order of protection. That is a criminal process. So they will have a bond set, and they will go in front of a criminal judge for the criminal trial. Now, the original judge who set the order of protection, whether it be the magistrate or the higher court being the family court, that family court judge will have a family court process, which is separate from the criminal prosecution, where that family court judge can institute other penalties and other sanctions. But in regard to the initial arrest, they will have a bond hearing. How long they're in there until the bond hearing arrives is varied around the state. And as to when that criminal trial will take place, that will also be scheduled by the magistrate or the bond judge or the clerk of court. So there's two processes that take place: the criminal charge to see if there's the guilty verdict or the acquittal, and then any other powers or resolutions which the family court judge or magistrate that set that order of protection deems as necessary to address that more or less civil side of the issue.
Is that a magistrate's court offense?
The
violation of order of protection?
Yes, it is.
As far as the criminal offense goes?
It's a misdemeanor, yes, sir, Your Honor. Excuse me.
That's all right.
You see the mode that I'm in.
Thank you.
Yes, sir, Representative Talon.
Don't do that. He'll get a big head and get all
It's just a no
swelled
hair.
and feel important.
Yeah,
So
that's
used to
right.
being in front of judges.
So, do you see the criminal part getting dismissed if they get before a family court judge at a later date? Because I don't think they get before them very quickly.
Yeah,
And will the magistrate hold off until the family court takes care of it and then dismiss the charges at that point in time?
It's been my experience that, and the experience of most of the officers that I've had the pleasure of working with, that they will have that misdemeanor criminal trial before they ever see the family court judge. And I have not seen, in my personal opinion, and my personal experience, I have not seen a summary level court judge call a recess or reschedule pending the family court ruling by the judge. I've never seen that happen.
Have you ever seen them put anybody in jail because they violated protection?
I have.
Yeah.
But I'll also say this, since it is a misdemeanor offense, and they did spend 2 or 3 days in jail potentially, or a day in jail, I've seen time served upon payment of a fine of, and especially when you get someone who repeatedly violates, there's no increase, it's still a misdemeanor. If there's a second violation of order of protection, misdemeanor, third, misdemeanor. So maybe that needs to be tied into maybe our degrees with the CDVs.
Tiered.
Tiered.
Thank you.
Thank you, sir. It's my pleasure.